Are live.
All right, welcome back to the House Judiciary Committee. Turning our attention to, it's a short form bill, but we have language that is on your desks, H 849. But to start this off, I do need a motion to take H 840 to take up H 849, which is a short form bill.
So moved.
I don't think I need a second, but all in favor, please raise your hand. Okay, so we can go ahead and we can have Hillary do a walkthrough of the proposed language, which is draft number 1.1. Thank you for being here, Hillary.
Happy to be here.
And just by way of introduction, this is just something that that I've been aware of this concept for the past couple months, and really it is, the bottom line is it's a bill that, you know, we have constitutional rights. We have some ways to vindicate those constitutional rights. There's a federal law that allows vindication of constitutional rights, which this is modeled after. And we want to look at the possibility of having a state cause of action in addition to that federal cause of action to vindicate constitutional rights. With that, over to you, Hillary. Thank you for being here.
Happy to be here. For the record, Hillary Cheddar Ames for the Office of Legislative Counsel. Chair LeBlanc just did my job for me. That is in a nutshell, but we'll talk about it in a little bit more detail. I have some slides for those of us who are visual learners. They're very simple, but since this is one of the more abstract legal bills, I thought it'd be useful to have a little bit of a simple reference point. So the plan for this morning: what's a cause of action? What's an existing law? What does H 849 propose doing? What are other states doing, or what have they done? And can states do this? So first of all, for those of us who did not go to law school or finish law school or have any interest in law school, what's a cause of action? It's permission to go to court. So to go into court and ask for something, you need some source of law to tell you that you can do it. And that's what a cause of action is. A cause of action generally says who can sue, who can they sue for doing what, and what can that person get. Here, we'll be talking about getting damages. When you see damages here, we're talking about money. So the idea is they compensate someone for harm that happened in the past, and they deter future unlawful conduct. So I mentioned you have to have a cause of action from some source of law. That can be common law. Generally, legislatures create causes of action, and occasionally courts will imply causes of action, but that's pretty rare. Any questions about our basic cause of action concept here?
Thank you for that. Like,
Let me just say, there are also some who didn't go to law school but are practicing attorneys and know all about causes. I just don't follow out.
Absolutely. I don't know which way it cuts, whether you get the good credit for deciding to still become a lawyer, for going law school, maybe a little extra perk there. So as the chair mentioned, what's an existing law? There is not a Vermont state or federal statute that creates a cause of action for damages against federal officials for violating the United States Constitution. There is a federal statute called Section 1983, and that creates a cause of action for damages against state or local officials for violating the US Constitution. And as we'll talk about shortly, H 849 essentially creates a state version of Section 1983 that also applies to federal officials. So Section 1983 was passed after the Civil War. Congress passed a bunch of civil rights acts, was concerned about state and local officials not abiding by the, that time, recent 14th and 15th Amendments. And that's kind of the origin of that federal statute. So this is not statutory law. Oh, yes.
Do you know what that was regarding?
What?
That original case that caused that.
That caused Section 1983. I'm not sure it was sparked by a case. I think it was more generally an observation that state and local officials after the Civil War in parts of the country were not keen on abiding by the new 14th and 15th Amendments. And so it was a general preemptive response to say, here is a way for people to enforce these constitutional rights that we have recognized.
Thank you.
No, of course, happy for questions throughout. This is not statutory law, but the US Supreme Court has recognized a cause of action for damages against certain federal officials for violations of certain constitutional rights in very narrow, specific factual circumstances. This did start with a case called Bivens. So sometimes you'll see reference to Bivens actions. But this is extremely narrow, and it's not clear how long all of these options will exist. A court can overrule prior cases. So there's a lot more there. Happy to answer questions about that later. And I think you'll also have witnesses who can speak to that in more detail too. So any questions about existing law before we move forward?
Thank you.
All right, now we've gotten to the bill. So what does H 849 propose doing? It proposes creating a cause of action for damages against a state, local, or federal official who violates the US Constitution. So if we turn to the bill language, I'm on draft 1.1 of the strike all, which has the actual bill language. This is page 1, line 8. This would add a new chapter to Title 12 and a new section, because this is a very, we want someone to be able to find where this is if they go to Title 12. And so a new chapter and a new section under it is the easiest way to mark that. What we've done previously in adding new similar sections. So this would add a new chapter to 205 called Deprivation of Constitutional Rights, and a new section. This is line 10, section 5797, Civil Action. You'll see subsection A on lines 11 through 19. This is not the most plain language way to say that someone has a cause of action against a state, local, or federal official for money damages if that person violates the federal constitution. But the bill uses this language because it is the language of Section 1983. So the federal law, yes. So the benefit or the reason to use that language is that it is referencing all of the case law, all of the understandings about the federal law, and just saying that this is a state version of that and that it would apply to federal officials. So there are a couple minor differences to the language in 1983 because of that change, but that's why it is phrased this way. So who can sue? Any citizen of the state of Vermont or other person within the jurisdiction of the state of Vermont. Who can be sued and for doing what? This is line 11. Every person who, under color of any statute, ordinance, regulation, custom, or usage, subjects or causes to be subjected any person in Vermont to the deprivation of privileges, rights, privileges, or immunities secured by the US Constitution. Under color basically means when someone is acting in an official capacity. So in our kind of short reference on this slide about actions for damages against state, local, or federal officials, under color is saying against those persons when they're acting in an official capacity. So that's where that's coming from. And what can a person bringing an action like this get? They can get damages for past harm. They can also get other equitable relief. Any questions about that first part of 849, that subsection A?
Angela.
I think I know, but can you say what equitable relief would be that the injunctions?
Yes. So equitable relief broadly encompasses anything a court wants to fashion. Generally, it refers to either an injunction or declaratory relief. Declaratory relief is a court declaring what the law is or what the person is entitled to. It's just an announcement. And an injunction either orders someone to do something or to stop doing something. and all of those kinds of relief would be available here. Existing law provides some more avenues to seek those kinds of things than to get damages under current law against state or federal officials. But both would be available here. Both are available under Section 1983. So again, this intends to, the way it is drafted intends to reference everything about Section 1983.
Thanks.
Tom?
So this would cover the way it's worded, non-citizens of the state of Vermont?
As long as they are a person within the jurisdiction of the state of Vermont, which I understand to be someone located here and who can be subject to suit in the state, bring suit in the state, who can file suit in the state. I'm happy to look further. The citizen language is from the federal statute. So I'm not certain that it intends to attach anything different with respect to Vermont than resident, but I'm happy to look a little bit more at the case law and see if there's more there. Yep. Yeah.
Okay.
I just got a confused look on my face. Aren't we, don't we already have language that's already covering this? I mean, it just looks like it's going into more detail of, again, language we already have or laws we already have. What am I missing?
So currently, if you, as a resident of the state of Vermont, if a federal official violates your constitutional rights, so this could be the kinds of constitutional rights that are often litigated under Section 1983 are excessive force by law enforcement. You can bring First Amendment claims under Section 1983. But for those kinds of violations, if that happens to you as a resident of the state, you cannot go to court and ask if that happens to you caused by a federal official. You cannot go to court and ask for damages to compensate you for the harm that happened to you. So you could go to federal court and ask for damages for harm caused by state or local officials who have violated your constitutional rights. But this would allow you to go to state court initially and seek damages for those kinds of harms.
It's state, local, or federal.
State, local, or federal. It is still likely to end up in federal court for a variety of reasons, but happy to answer more questions about some of those details along the way.
Yeah, thank you. I've gone away for witnesses, I think.
So the other thing it would allow is for someone who's got a 1983 claim against a state official to bring that in Vermont and not have to bring it in federal court.
Correct. They could bring that in state court.
My only other question, and I don't know this very well, there is cost shifting for attorney's fees for certain 83 claims, I think.
So
would you also get this in this one if you brought them correctly?
Policy decision for the committee as draft. So Section 1983 does not specifically itself reference attorney's fees or cost shifting. There's a separate federal statute that says that attorney's fees are available under other federal statutes, one of which is Section 1983. So as drafted, this is silent as to attorney's fees. Generally, silence about attorney's fees means they are not available. Whether to include them is a policy decision for the committee.
Is equal access to justice. Isn't that the federal law?
I'm gonna ask the same questions that have been asked and make you repeat the same answers in a sense. So we have a federal law
Mhm.
and this language for Vermont, 95%, I'll use that percentage, goes with federal law, except for tweaks we need to make it applicable to state government officials, Vermont state government officials. Is that pretty close?
One tweak at the end to make it applicable to federal government officials.
Okay.
So the federal law covers state and local officials, not
Okay.
federal officials.
The federal law doesn't cover federal.
Correct.
Okay. Surprise, not surprised.
I think I mentioned the origins of the federal law, section 1983, to perhaps offer an explanation as to why they were focused on state and local officials. This was post-Civil War. It was originally called the Ku Klux Klan Act.
Okay.
That's what they were concerned about at the time, and perhaps a reason why they referred only to state and local officials. But this law would create a federal causes of action. You have to bring in federal court, but if a state creates a state cause of action, you can bring it in state court, and it would allow you to bring the same kinds of claims as the federal law in state court against state and local officials. But the new thing that it would cover would be that you could bring those claims against federal officials. I'm glad you asked the question. That's probably the clearest explanation I've given so far. So you gave me the chance to tee that up.
And there will probably at some point, but I may be jumping ahead of myself of being a challenge of whether we can actually do that. And maybe that's what you're supposed to talk.
We are definitely headed there.
Okay.
Other questions? I guess before we get there, just one note. Are other states doing this? Do they have laws like this? Are they considering bills like this? So some states have had laws on the books for a while that do a version of this. They create causes of action for interfering or attempting to interfere with state or federal constitutional rights by using threats, intimidation, or coercion. So in a sense, they're narrower because the constitutional violation has to be using threats, intimidation, or coercion, which is like a more specific factual scenario. It's going to not be all constitutional violations. But in another way, some of them are broader because they refer to both the federal and the state constitution. And some of them are not limited to officials. Some of them require that it be someone acting under color of law, which means acting in their official capacity. But some of the laws refer to anyone, whether or not acting in their official capacity. So those are slightly
You said some of the laws refer to anyone, which would be anybody walking down the street.
correct.
Thought it was only government that could restrict constitutional rights. Yes, no?
Ideally, the government's not restricting constitutional rights, right? I have not looked at the cases under some of those state laws about who they're actually bringing them against. But as written, they're not limited to people acting in their official capacity. So you could have a private person who, I guess, anyway, I'm not sure exactly the factual scenario that's covered. You're pointing out that it seems odd that a private person could violate someone's constitutional rights. So I'm happy to look for an example of when that happens under those laws.
Okay. Thank you.
Yeah, no, it's a good question. This is a big area of law. I have done my best to do an overview for you, but there's lots that I would have to follow up. So happy to do that. That law is different than this one. So just saying that those existing laws are a version of this, but they're not written exactly like this one, including for that reason. This one is under
You know what?
color of law.
I don't need an answer to
Okay.
that. No, I really don't, if it's not in our law, but.
Yes, this law is under color of law, which means in an official capacity. But I just did want to reference that some states have been doing a version of this for a while. Other states are considering bills that are similar to H849. So California and New York, a couple others, but California and New York's bills are more similar. There are some differences, which I'm happy to talk about, but they are considering doing very similar things to what H849 would do.
Okay.
Thank you. It's always helpful to see, are we the first doing this, or are we kind of following others? And so for those that have been existing, realizing it's not as similar to what we have in front of us, those have been upheld and.
I'm happy to look more closely at challenges to those laws. There are certainly, I know of one case with respect to New Jersey, where like a certain application of the law was not upheld, perhaps for some of the reasons that we've talked about. So I'm happy to look at more of the existing laws, but none of them were challenged on grounds that would apply to this one. I mentioned that California and New York are considering bills. Illinois passed a version of this last year, but theirs is meaningfully different for a couple of reasons. One of which is it is limited to actions against people conducting civil immigration enforcement. So very specific and narrow, which raises some challenges. It also is based on violations of both the federal constitution and the Illinois constitution, which if you apply violations of the state constitution against federal officials can also raise concerns. Both of those parts of the Illinois bill are not applicable here, but Illinois passed that in December, I think signed into law in December, and the United States has filed suit challenging it. There hasn't been any progress in the case since then, but so all of that leading to the can states do this question. It's an unsettled question of law with respect to federal officials. There are two likely issues that would come up. The first, I think you talked about with Sophie earlier this week with respect to S208. This is intergovernmental immunity. State laws can't directly regulate or discriminate against the federal government. Because H849 applies to state, local, federal officials, it doesn't raise concerns about discriminating against the federal government. I think a federal official or the federal government could argue that it directly regulates the federal government. I think in the Illinois case, they are raising a version of that argument. Although the Illinois law also arguably, they've argued it discriminates in a way that they could not argue here. The direct regulation argument is something along the lines of, if you are creating liability against federal officials, then you risk kind of chilling their conduct in a way that changes their conduct. And if you're trying to change their conduct, then you are directly regulating it. That's the kind of argument that the federal government has made in Illinois, and that's the kind of intergovernmental immunity argument they would raise. I think the argument on the other side, which is fairly strong, is that a law like this is not trying to place state law over federal law. Like our big concern with intergovernmental immunity is the supremacy clause. Is federal law supreme? This is really lifting up the federal constitution, so it's consistent there. And it's not creating new rights or responsibilities. It's just requiring that federal officials and state and local officials abide by the Constitution. And to the extent that the federal government were to try to argue, they'd have to argue that they have some legitimate federal government goal or objective that this law interferes with. But because this law only prohibits unconstitutional conduct, there's no way that the federal government could argue that they have a legitimate federal interest in unconstitutional conduct happening. So those are the arguments on both sides. As always, coming from Ledge Counsel, I am not a court. I cannot predict what a court will say. I can offer kind of both of those arguments and say that there is certainly merit to the argument defending a bill like this. And I think you will hear from further witnesses about kind of the relative risk or strength of some of those arguments. Before I go into federal preemption, nobody's favorite except for maybe me. Any questions about the intergovernmental immunity piece? I do think you'll have chances to ask more questions of other witnesses, and I'm also happy to follow up on other questions if you have them.
There you go.
So federal preemption just asks whether Congress, in passing laws, expressly says or suggests that they don't want states to do something. So if Congress in a statute says you can only use our statute, that means states can't do something in that area. Or if the way Congress structured a statute suggests that they only want the federal law to operate in a space, then the state can't do something. So here there are two federal statutes that touch on the topic of when you sue a federal official for damages. there's the Federal Tort Claims Act, which is if you sue a federal official for negligence or another regular tort, basically the US steps in as a defendant and they would pay if that were the outcome of the suit. The Westfall Act is a separate federal statute. And it says that if you're going to sue a federal employee for something covered under the Federal Tort Claims Act, that's the only way you can do it. You can't have another cause of action that tries to get damages if it's something covered by the Federal Tort Claims Act. Basically says, if you're in Federal Tort Claims Act territory, you have to stay there. Only way to do it. The Westfall Act does have an exception, which is it doesn't apply for actions brought for violations of the US Constitution. So there is an argument that, I guess I would say the arguments on both sides are that if a federal official, if this were to pass and a federal official were sued, a federal official could say, this falls under the Federal Tort Claims Act. The US needs to step in and litigate it. It comes into this area. The argument on the other side would be that a constitutional violation is not the kind of regular tort that the Federal Tort Claims Act covers. So we're not even in Federal Tort Claims Act area to begin with. And even if we were, that this kind of suit would be an action brought for a violation of the US Constitution. And so it falls outside of these statutes and would be allowed. Very plain language, simplified version of preemption. But the takeaway is that this could be an issue that comes up. There are arguments to justify what the bill would be doing. There are scholars and jurists who have commented on both sides of how to interpret those statutes. It's not a settled question of law. We don't have a clear answer. And I think that there will also be, I understand that there may be future opportunities to ask other witnesses more about this question to the extent folks are interested. But any questions on the can states do this question?
Not at this point. I'm sure we'll.
All right. That is the close of my walkthrough of 849. Happy to answer any other questions the committee has about bill text or anything that I've mentioned today.
As far as in states do this, yeah, we could do it.
Fair to question the way that I framed.
What happens down the road is another.
Yeah, we can pass a law. Now,
Right, well, right, yeah,
Will it be upheld?
right.
I have
And
one.
I gotta believe since it's against. Federal government, I guess it would be again. Just a guess.
I would anticipate there being a challenge if we pass this. Maybe worth it. So, Ian.
Just one question. There are requirements to bring suit in federal court for like a civil action like this that don't exist in Vermont court, correct?
What kinds of things do you think?
Like a damage. Yeah, I don't know what the right word is for it, but do you know what?
The one that I'm familiar with is that, so to be in federal court, you either have to have like a federal claim, federal question, or you have citizens of different states with a minimum damages cap. This gets into some interesting questions about what kinds of court this could end up in. Someone bringing a cause of action under this could choose to be in state court. If it's against a state or local official, it would likely stay in state court. If it were against a federal official, there's a federal statute that allows federal officials to remove cases from state court into federal court. So it's likely that it would end up in federal court in that case. It's also possible that a plaintiff could try to bring a case under this state cause of action directly into federal court because it implicates a federal constitutional violation, which is a federal question on the face of the claim, which is the kind of thing you can bring directly into federal court. So I'm not sure if that quite answers your question.
No, it does. It does. Yeah, it's helpful. I think I'm just thinking about the question around the federal officials and how that will work is really interesting. The other half of this that I see impacting Vermont is just that there are a lot of 83 claims filed in federal court here, and this would give opportunities for people to file essentially an 83 claim in Vermont court for against Vermont officials. And that's interesting, and I'm just sort of trying to understand how that would impact those type of claims. And if if there's anything that I'm trying to understand.
Yeah, I think that might be a question for other witnesses.
Yeah.
I do not regularly litigate Section 1983 claims.
Yeah.
So I'm less able to immediately answer what the differences would be
Yeah.
in having that kind of suit available in a federal court versus in a state court.
Yeah.
But I think a very interesting question. It's a good question.
Great. Thank you.
Questions? Not seeing any, so we are gonna have, are we gonna have Emily or Falco testifying on?
I think we're gonna do both.
Okay.
Have Emily start and then I'm happy to follow up and supplement.
Oh,
I
okay,
think
Emily's online, all right, so we'll just have the two witnesses from ACLU, and then we're gonna adjourn for the day, so people can get on the road. So we'll just plug away through lunch.
Mr. Chair,
Yes, folks.
I had a quick question for Ledge Counsel, but I
Oh.
guess we already,
No, that's go ahead, you can ask the question.
in relation to legal fees, as you mentioned, would we just amend this bill to include the language that you suggested?
If the committee, policy question for the committee, whether to provide for attorney's fees, if the committee made that choice, then yes, the bill would include, you would add language specifically saying a court may award attorney's fees essentially, or whatever other kind of additional requirements or authorizations you wanted to make. We talked about the basic parts of the cause of action. We can specify a lot of other things about what can happen with that kind of case. So if the committee is interested in pursuing any of those, it's a policy decision, but I can certainly help with language and schemes related to that.
Okay, thank you very much. Because when I think about what the chair said earlier in reference to our mission, one of our missions or part of our mission as a committee is to ensure that Vermonters have access to justice. And so a key piece to access to justice is access to an attorney. So I think you see my thinking there.
No, I appreciate that, Coach. So we'll certainly hear from witnesses on that, and we'll have further discussion as well.
Great.
So, Falco, do you want to join us there as well? And I know we may lose some of our members who have to head further south, and we're concerned about the weather. I know Tom has to have to leave sooner. But that's the wonders of YouTube, that these are all on there, so people can stuff. You're making fun of the boomer.
What did he do?
I think you made fun of the boomer, I think, so I did. Thank you for being here, Falco, and thank you, Emily. So proceed.
Yeah, thank you so much for the opportunity to testify today. Getting back for the third time this week and been able to spend a lot of good time together. For the record, my name is Falco Schilling, and I'm the Advocacy Director for the American Civil Liberties Union of Vermont. I'll let my colleague introduce herself, but I think what we're going to do today is Emily's going to go over kind of a broader overview of why the ACLU supports both this proposal and other proposals like this around the country, some of the landscape. I think Ledge Counsel did an excellent job covering a lot of that ground, so some of this might be duplicative. And then I'm going to speak a little bit to the language itself and then be happy to take some questions.
All right, over to you, Emily, then.
Hi, everyone. Thanks, Falco. I'm Emily Dindile. I'm a senior policy counsel at the ACLU National Office. Thank you so much for having me here today. And I agree with Falco that Ledge Counsel overview was dead on and covered a lot of what I was going to touch on. So I don't want to be too repetitive. I know that we are at limited time here. So, you know, I guess I'll just say that yeah, it is the ACLU's position. We agree with Ledge Council that states absolutely have the authority to do this, that there are certain constitutional considerations, to take into consideration when drafting, but 849 as drafted, in our opinion, is constitutionally sound and should be upheld in light of those constitutional considerations.
I apologize, Emily, before you go on,
Please.
I want to just make clear, if you're in a position, you can advocate more. Our legislative council certainly laid out the arguments on both sides. You're welcome, and you just said that you think this will prevail constitutionally. I just want to make sure that we understand the difference from where we're coming from with legislative council. So advocate away is what we're asking for.
Non-partisan legislative council.
Not a partisan, not non-partisan. So go ahead. I'm sorry.
I appreciate that. I appreciate that. I think that an important thing that she said is that there's very little precedent. So, of course, it's hard to say one way or another, but our position would be that the only reasons this would be constitutionally infirm would be if it would violate some provision of the Supremacy Clause, namely that there's a conflict between a state law and a federal law. That's, and then the Supremacy Clause would require favorability of the federal law. In this case, our opinion is that there is no conflict. That's because the goal of a converse 1983 statute is to fill a gap that doesn't exist, meaning there's no conflict because there's no federal law that currently would allow a private individual to sue a federal official for a violation of the US Constitution. So our position is that there's no conflict there. The other concern on the Supremacy Clause issue is whether the state is discriminating against the federal government. And that's where this concept of ensuring that the law applies to all government officials equally. That is how you would avoid that argument. And so some of these other statutes that have been challenged or raised certain concerns, such as the Illinois Bivens Act, the language there, for instance, was specific to civil immigration enforcement. So the federal government's argument that discriminates against the federal government would be stronger there, in our opinion, because that's civil immigration enforcement is squarely within federal law for the most part, as opposed to the way that 849 is drafted to include anyone under the color of the law, federal, state, local. That is, in our opinion, how you overcome and withstand the constitutional issue of discrimination. I'll pause there. Does that answer your question on the issue of the constitutional claims?
I think so. I mean, unless you want to dive deep into preemption as well. And you don't need to if you don't want to, but
no, I think one of the things that we're coming from as the ACLU is really addressing this gap and the issue of there being a gap in enforceability of constitutional rights that we want states to fill. And so I can talk a little bit more about the gap. I think Ledge Council did a great job. It basically, the problem is that right now for private individuals to sue a federal official for a violation of the US Constitution has largely been left to federal law. Either there's the 1983 statutory provision that is limited to state and local officials, as someone aptly called out. It's a federal law that does not allow federal officials to be accountable. And then that gap was somewhat addressed by the Supreme Court in 1971. That was in the Bivens lawsuit, where the court found that there is a constitutional right for individuals to sue federal law enforcement or federal officials for violations of the US Constitution. However, that opinion was never codified. So we still don't have a federal law that is analogous to 1983 that would allow private individuals to sue federal officials for violations of the Constitution. Also, that Bivens claim has been watered down to the point where, in practice, it simply is insufficient. And so our position at the ACLU and a lot of our coalition partners working on this is that this is a significant gap that affects people's civil rights protections, because without an enforcement mechanism, without a remedy, there's really no right. And that this isn't about creating a new right. This is about ensuring that there's some kind of way to enforce that. And that it's completely appropriate and frankly necessary for states to do that. And that we just want to encourage states to do that in a way that, we're here to advise you on our opinion on how to do that in a way that is constitutional. And again, I believe the draft as written would meet those concerns. And the only thing that I would add is that there's even more states than, I think we are now at 13 states who have bills on this of varying degrees, but that the ACLU across the country is supporting for this reason, that there's a gap to fill. And I just want to, if it's helpful, the other states are Colorado, Georgia, Maryland, New Mexico, Washington State, and Wisconsin, at least. And we are hearing rumblings that other states are preparing to file as well.
Okay, great. Questions for not seeing any right now, so we'll, unless there's anything else, Emily, we'll go to Falco.
All right, I'll pass to Falco. Thank you very much for having me.
Yeah, thank you for being here.
So thank you. First, before I dive in, I do want to note that you might see that there's more folks around the room today than maybe some other times. Today was the ACLU Vermont's Lobby Day. Just coincidentally, we scheduled this months ago, and it happened to be today. So there's a number of folks who are joining here, and I think watching down in room 11, who are just interested in this testimony and all the really good work that has been happening in this committee. So I just wanted to let you know who the folks around the room where the name tags are.
So before you start, we did this when we had only 4, but I'm going to do it again. If you could go around the room and just introduce yourself and where you're from in the state.
Spence Putnam from Weybridge.
Thank you.
Winnie Wilkinson from St. Albans. Jessica Neary from Linden. Eddie Keller from St. Johnsbury. Kathy Mann Stanville. And Pat from Linden. In charge of Shelburne. Megan Garrison.
Annika McCann, St. Johnsbury.
Molly Rowland, Burlington.
Thomas Rowland, Burlington.
Ian Moore, St. Johnsbury. George Priscilla Stanville. Jim Wolf, Burlington.
Dave Rappaport, Burlington. Thank you all for being here, and you're always welcome to come and sit in on things or just watch us on, what do you say, YouTube? YouTube.
Let's plug Falco. This is the inaugural day of the ACLU Lobby Day.
Okay, great.
It's our first time.
We'll expect to check every year. So
Yes.
wonderful.
Same time next year.
Can you introduce yourself?
Thank you so much.
You want to chair?
I really appreciate that, and I'm terrible at that. I'm Martin Lalone, representative from South Burlington, and I've been on this committee for 12 years and been chairing it for the last 3. So
Last 6.
6, no, 3, 4. This is my 4th year.
Kenny Bosan, I'm a state rep from Northfield and Berlin. Been here 8 years, all in this committee. Nice to have you here.
Hi, everyone. I'm Angela Arsenault, a representative from Williston, in my 4th year and 4th year on this committee.
Hi, everybody. Karen Dolan. I'm a representative from Essex Junction.
Good afternoon. I'm Tom Oliver from Sheldon, Swanton, and it's my 4th year.
My name is Ian Goodnow. I represent part of Brattleboro, and I am the junior member of the committee. So I've only been, this is my second half of my first biennium, so I've only been on for.
My name's Tom Burdett from West Rutland, the vice chair here in House Judiciary. And my 16th year in the building and my 12th year in the committee.
Wow.
And Coach, could you introduce yourself and then Alicia? We have two members who are on Zoom as well. Or Alicia, if Coach is not available right now. Yeah.
Yeah, no, I'm here. Hi, Alicia Millay from Pittsford, represent Pittsford and Proctor.
And if Coach might not be there right now, so back over to you, Phil. Thank you.
So I really appreciate the committee taking this bill up, especially as a short form. And I would echo everything that you've heard from Ledge Council and from my colleague earlier. We are strongly in support of the language that's included in HH 49. I think in terms of the strategies used for drafting it, we saw this language last night, and we're very, very happy to see the choices that were made in going into this draft, really modeling it after Section 1983. This is also limited to state claims, or limited to federal constitutional claims, which I think avoids some of the other concerns that folks have raised in other places. And I think, just high level, the goal of this, as we said, is to address a gap. It's not to create new liability for state and local officials, but to address that gap where there's federal officials who might engage in unconstitutional conduct, and then there's not recourse for the citizens of the state of Vermont to be able to adequately bring those claims forward. And that's something we want to have under state law so folks can vindicate those claims. And I think we talked a little bit about this in talking about Bill S-209 earlier when we were talking about some of the regulation on sensitive locations. In particular, we were talking about folks trying to exercise, for instance, their Fourth Amendment rights. And that is one of the strongest protections folks have. But as we've also heard that, there's no rights without remedies. And if there's violations without the ability to actually get recourse or damages or equitable relief, that seriously undermines folks' constitutional rights and their ability to vindicate them. So that's why we're strongly supportive of this piece of legislation. We think at this moment in time, it makes a lot of sense. And there's some urgency around it. So my only two changes that I would, hope the committee might consider with this bill. First is what Coach brought up in terms of the addition of attorney's fees. It's correct that this is modeled very directly off of Section 1983 with the addition of federal officials. But we would suggest, importing similar language to what currently exists under 1983 for attorney's fees, which is generally reasonable attorney's fees and litigation costs. So that's something that we would suggest. To Coach's point that he made, it's hard to access justice when you can't access an attorney. This allows folks to take these cases on when there might be a violation and the opportunity to bring that forward. So that's something that we would suggest in the spirit of trying to mirror how 1983 operates currently and importing those same rights within to state law. And the only other change is I think we would advocate for making the effective date upon passage, just because this is, the longer we go without folks having the ability to vindicate their constitutional rights, the more likelihood that there are constitutional violations where folks don't have the ability to seek recourse. So that's the only other change we would make to the bill as introduced. And so long and the short of it, we're very supportive of this piece of legislation. Happy to answer more questions in terms of how things might operate. I think and Ledge Council did an excellent job, but we'll leave it at there for now. Just know that there's a wide range of folks across the country who are interested in looking into this. You have a number of different pieces of testimony that were submitted on your website that I hope folks might take a look at. If there are more questions, including from folks at Popular Democracy, Institute for Justice, scholars out of the University of Wisconsin, who have looked into this and spent a lot of time thinking about it. So I hope folks can review those. We're also happy to answer more questions on the stand.
Yeah, not a question for you, Falco, but on the effective date, would we be able to do it on passage? And I'm thinking, is there anybody that has to, in the state government, the judicial system or whatever, that would have to do any education to bring people up?
Yeah, we could.
So
Yeah, we could have some of the other witnesses.
unanswerable right now, but
Are there more types of damages and claims that can be made under a federal 83 claim currently beyond just attorney's fees?
There's reasonable litigation costs, attorney's fees, but then of course there is damages for injuries incurred. Emily, I don't know if you want to speak more to this or you have this off the top of my head, but I think you need to be able to prove those monetary damages. So those would be things like damage to property and intentional infliction of emotional distress, but you have to be able to demonstrate those real money damages to collect. Emily, did I get that right? Is there anything you want to add?
You got that right. There's compensatory damages are available under 1983, I'm pretty sure.
And is there, just one other question, are there types of damages available for particular types of claims brought under 83? So like a discriminatory claim or that's like the, I don't want to, if we're going to add that in here, I just want to make sure that we're capturing all the different ways that 83 is used now.
Yeah, I think, Emily, you can speak to this as well, but generally, I think if there are, I don't have that off the top of my head, I could look into case law, but I think the idea is that case law would then be very informative in state courts and how they would apply it in a similar manner if there are differences in the ability to recover. Statutorily, I think we could look to, I forget the statutory site off the top of my head, just in terms of enunciating the ability of attorney's fees, but I think modeling that off of, because it's not within 1983, I think it's 1980. I forget off the top of my head, but I think modeling out that off of what it currently exists, so we have as much cohesion between what exists in federal law and what we'd be putting in state law, that would be the avenue that we would suggest.
Yeah. Okay. Thank you.
I agree. And I'll just say we'll follow up. I think we should follow up with more specifics on that to confirm.
Can you, again, I know that Hillary mentioned this, but by following the language in the federal law, we're also going to be taking advantage that it's not brand new for courts when they take it up. There's going to be a lot of precedent that will help us understand how this would be applied.
Yeah, I think that's correct. And what you heard from legislative counsel is when these suits proceed, it's most likely that they would then proceed in state courts, which have the history and practice of hearing. Then federal court, start in state court, then probably most likely be removed to a federal court. And that's where those claims are heard now. And they would be, basing how those claims proceed off existing jurisprudence, which, we have not seen this play out, but that's most likely how it would happen. And I'll also once again defer, Emily, if you have anything else you want to add.
Can you just explain for us, because that was mentioned a little bit before, that maybe this is getting into the weeds too much, but I'm going to take a chance of what removal means. If you start a case in state court, why would it get removed to federal court?
Because my understanding is that existing statutes allow federal officials to say, based on this type of claim, we think the correct venue is within federal court, and you can make that petition. And then based on existing rules and statutes, there would be the ability to remove it to a different court because that would be the appropriate venue for that claim to be heard.
The court would still be looking at the state law and application of that.
Right.
So with the lawyers being paid, say if I bring a case forward and I lose, would my lawyer fees be paid?
My understanding is no, but Emily, you can back me up on that.
No, and that's good. I would have issues with it if they were paid. Somebody who was definitely discriminated against or their constitutional rights were, infringed upon, don't have as much problem. But if you lose your case and it's deemed that, nothing happened to you, I think it should be up to you to cover.
It's generally referred to the prevailing plaintiff. So the court has to decide that the plaintiff was successful in some way to then award attorney's fees.
Oh, okay. Thank you.
Sadly, I had to defend some of those way back when in the Department of Justice, which means I have lost cases. But I'll put that aside. It's funny anyway.
If you had never lost any case, I would say you've only done one case.
Right. Well, that's true too. Any other questions for Falco? So So thank you very much for the testimony,
Thank
and we'll be having more testimony next week. On Tuesday, we have Professor Fander from Northwest Pittsburgh Law School going to be in, and Tucker Jones from from PPS. And at some point, Julio Thompson, and we'll figure out Judge None will bring in as well. So we'll have testimony during the week next week. So we are adjourned until 1 o'clock on Tuesday next week. Everybody drive safe and